We start with the big story that comes from India, where the apex court has upheld the constitutional validity of India's unique identification scheme, Aadhaar, but with several conditions. Now, the biggest concern about the biometric scheme was privacy. The Supreme Court of India has said that Aadhaar Act does not violate right to privacy of Indian citizens. The court is convinced that Aadhaar cannot be duplicated. The court said the Aadhaar scheme empowers people on the margins of society and gives them dignity, and that, according to the court, far outweighs the harm. But while upholding the scheme, the Supreme Court said that private companies cannot insist on Aadhaar. Neither can school authorities or examination authorities make Aadhaar mandatory. Importantly, the card is not required to open bank accounts or obtain a mobile phone number. But Aadhaar remains a must for PAN cards and filing income tax returns. The Supreme Court delivered a majority judgment. In fact, one of the judges said one can't throw the baby out with the bath water. To address security fears, which has been consistently raised by petitioners, the court said that the centre must bring in a robust law for data protection soon. Justice Chandrachud, however, held a different view. He agreed with the respondents that security and safeguards have fallen short of standards required to protect privacy and data protection. Justice Sikri also made some interesting points while reading out the verdict. He said that it is better to be unique than to be the best. He added that Aadhaar gives an identity to everyone. So these are some very interesting points that have emerged out of the judgment so far. There are some other broad points which we would like to point out to you, that private companies cannot demand Aadhaar. Children cannot be denied any benefit due to not having Aadhaar. So no Aadhaar is needed for school admissions or any other government scheme which benefits children. You have to link your PAN card is the third point that you can keep in mind with the Aadhaar, but don't have to provide Aadhaar to banks, telephone companies or any other corporation. Individuals can approach courts to file cases under the Aadhaar Act. And let's also speak about Justice Chandrachud, who had some very interesting point of view to present. And he also said that the Aadhaar Act need not have been a money bill. One of the clauses of contention was the fact that the Parliament had passed the Act without the Rajya Sabha debating it. This is because it was classified as a money bill. However, Justice Chandrachud had said that he differs with Justice Sikri on whether the bill should be a money bill. And Justice Chandrachud has said that it should not have been a money bill. He also punched holes in Aadhaar's safety, and he agreed with Justice Sikri that Section 57, which requires private parties to seek Aadhaar, is unconstitutional. He said that seeding mobile phones with Aadhaar data poses grave danger to individual liberty. And in his judgment, Justice Chandrachud said that he has instructed telecom operators to delete all data they have collected from users. And it was just some time ago that Justice Ashok Bhushan also read his judgment, saying that he broadly agrees with the judgment of Justice Sikri, which is the majority judgment. A lawyer for petitioners, Prashant Bhushan, has said that the Aadhaar judgment is a major relief for people speaking outside the court. Lawyer Prashant Bhushan said that the court has ruled that Aadhaar will not be mandatory anymore, and that there was a difference in opinion over whether the legislation could have been passed as a money bill. He also said that Justice Chandrachud's judgment was a very strong comment on how the bill has been passed by Parliament. Bhushan has also said that it gives major relief to people who have been complaining about needing Aadhaar for everything. Additionally, there have been reports saying that the judgment may be a 1,000-page long. It's a heavy reading verdict, and indeed a very, very exciting day for India. Also a historic verdict which spanned over 37 petitions, and this has been the second longest hearing in terms of any case, especially after the case of Ananda Bharti case, which took place earlier. So it was a 5-judge bench that determined the use of Aadhaar, which according to petitioners violated the right to privacy, and that they demanded it should be struck down. The Supreme Court has given its decision on these petitions seeking live streaming. So the SC order, of course, has implications for linking Aadhaar to government welfare and financial inclusion schemes, which have, of course, been struck down according to the new verdict. And to bring us more details, I am now joined in by senior correspondent Jessica Taneja, who reports from New Delhi. Jessica, indeed a very exciting day for the entire country as a historic verdict is finally out, but more or less a very balanced verdict to say, because it has at the end of the day, aimed and attempted to preserve the privacy of the citizens.
Well, absolutely. Well, the apex court, of course, it's a 4:1 judgment, 4 in agreement, 1 dissent, which is Justice Chandrachud. Now, Kansha, we need to understand what and why things were said by Justice Chandrachud and what he meant when he said a lot of things, that the government needs to have a stringent data protection regime in place in order to ensure that the data is not misused, it is not given to third parties. Remember, this was challenged on the ground of not only right to privacy, but user data issues and the privacy right issues that come with it. Now, if you can recall a little, when the Attorney General A.K. Venugopal had told the court in his beginning arguments while he was submitting to that constitution bench, he said that the citizens' data that is collected through Aadhaar scheme is safely secured inside a 13 feet high and a 5 feet thick wall. And that, of course, made national headlines. But an important point to understand is what Justice Sikri added to that. He said that, yes, the citizens' data is taken care of. Therefore, the constitutional validity of Aadhaar is upheld. But at the same time, individuals, citizens of this country cannot be forced to link their mobile phones with Aadhaar. They cannot be forced to link their bank accounts, yes, for income tax returns. And other welfare schemes, it is important to ensure that there is transparency and there is no misuse, because what is given from the government side to the people, it doesn't necessarily reach them. So judgment has been very balanced yet complex.
Right. Jessica, I'm also joined in by senior Supreme Court lawyer Gaurav Kant, who joins us live from the Supreme Court. Let's quickly go across to Mr. Kant. Mr. Kant, a very warm welcome to you here on Wion. How do you view this verdict? And let's also keep in mind the only dissenting voice, which was that of Justice Chandrachud. And he actually also, shaped the perspective of the citizens' privacy, being an integral part of the verdict.
Yeah, well, the only dissenting thing which Justice Chandrachud had added here is that it cannot be termed as a financial bill the way it has been introduced in the parliament. It doesn't really qualify for the term financial, and this should have been a natural bill, because he says that since the money is really not flowing out of consolidated fund of India, or you cannot term it a financial bill, it should have been a regular bill and should have gone to the Rajya Sabha too. So it should not have only been tabled in the Lok Sabha and got the assent of the president, but also to the extent that as far as the safety and security and privacy angle is concerned, this is not really an adequate safeguard which has been provided in the Act. But I feel the majority of the judges have held in favor of the Aadhaar Act, and they have seen to it that as far as the privacy and other safeguards which are there are taken care of, and that is the reason why some of the provisions have been struck down to the effect that it cannot be shared by private parties and they cannot insist on having an Aadhaar number. So there are a lot of inbuilt mechanism which is already being laid down by the Supreme Court. We will see more of it when the judgment comes out in totality. but it seems like the Supreme Court has taken the concern of the people as far as the safeguarding and privacy is concerned.
Right.
And the
Mr. Kant, completely agree with you that a lot of inbuilt
validity
mechanisms have been kept in mind to safeguard the privacy of the citizens. Thank you so much for bringing us your perspective here on Wion. Also thanking our senior correspondent Jessica Taneja, who's been reporting non-stop from the Supreme Court. And we will continue to track the latest on the Aadhaar verdict.